Hi, welcome to valuationpodcast.com, a podcast and video series about all things related to business and valuation. My name is Melissa Gragg, and I provide online divorce mediation and valuation services based in St. Louis, Missouri. Today, we're going to discuss the marital balance sheet, trusts, and divorce with Bob Boyd and Tish McDonald from Atlanta, Georgia. Bob is a co-founder of Boyd, Collar, Nolen, Tuggle, and Roddenbery, and a leader in family law who has received recognition from his colleagues across Georgia and the nation for his work in high net worth divorce litigation and contested custody cases. Tish McDonald is a partner in the trial and global practice group at King Spalding. She focuses on complex commercial litigation with an emphasis in trust and estate litigation. She also gets involved with litigation for nonprofits, real estate, and government entities. When you're actually creating trusts in the divorce, and I think, Bob, you kind of alluded to this, I've seen where they've created trusts and put money in it, and everybody thought that we were putting money in, okay, for the kids, but now we don't have a lot of cash and we're getting divorced. And we're like, wait, we put that money in for the kids, but can we bring it back? You know, like that. I don't know if I want to do that anymore. We need the cash. And so we'll see different things where even if everybody was on board or kind of on board or, you know, implicit trust of everything going on, that they actually want to bring it back. So what types of situations are you seeing where the actual creation of the trust also complicates the divorce? And sometimes it's for gifting purposes, right? I mean, that's a lot of the estate planning is how do you move and gift, especially in this time when you can gift $10, $11 million, you know, tax-free. How do you get that into the hands of your kids? But then you get divorced and now what happens, right? So maybe Bob can talk a little bit about some of those complications.
So, we recently had a case where husband had a business and he sold it. They got a lot of money, and he and his wife, I believe his wife was a lawyer, as I recall, they decided to set up an irrevocable trust to protect the money from the government in case something happened to them. They got somebody to be the trustee that they agreed on. The wife was also a trustee, but it had the kick-out provision that we talked about, that in the event of divorce, she was out. So the husband was not a trustee. The husband was not a beneficiary. The wife and the children were the beneficiaries. And so they're going to get divorced now, and they're just in the place you said. Hey, wait a minute. You know, how do I get my money? Well, you sort of don't. And fortunately, what happened in that situation is that through some work with their estate planning lawyers, we settled the divorce by letting the trust buy certain assets for each of the parents of the children, for the benefit of the children, so to speak. Agreed that the trust would pay certain things for the children. Agreed that the trust would pay certain things for the wife and the husband, so that they actually ended up getting the benefit from the trust that they had originally intended, even though they were divorced. Now, that was a good situation, right? Because everybody was they realized they were in it together. Nobody was trying to cut anybody's heart out. It was okay. So that's the easy situation. The other situation you get is the one that Tish and I had to try in court for a week, where one spouse sets up the trust, doesn't tell the other. The settlor is not a beneficiary, is not the trustee. What happens to the money that went into the trust? Because when they're getting a divorce, the wife wants her share of the money. She's not interested in it staying in the divorce in the trust. That's where you have problems.
And one thing just to point out, when we talk about, affectionately call it the divorce kickout clause, which says if you are a spousal beneficiary and you get divorced, you're no longer a beneficiary. In litigating these trust and divorce cases, it always seems people make a big deal over that. Like that's something weird that provision is in there. It's very common to have a provision like that in there, especially if a business interest is being transferred into the trust as to which one spouse doesn't have an interest.
Right.
But people always panic over that. Another thing is Bob talked about in the case that we tried, we happened to represent the husband. And again, he was not a beneficiary. He set this up for very valid reasons. He needed asset protection given the nature of his business. The wife is kicked out. They had one daughter who was going to be the sole beneficiary. And so you would think that the spouse, in this case, the wife, would say, well, at least it's going to my daughter. At least it's going to go to my daughter. And I understand that. That's not what you see. What you see is you see that spouse saying, look, you can do with your half what you want to. You can put it in trust, but I want to take my half and make my decisions. And so with divorcing spouses, you sometimes don't always see a lot of, how do I put this, acknowledgement that at least the kids are going to get it. And in fairness, sometimes the spouse that ends up not being the beneficiary is because there's not a whole lot outside of the trust. And that's when you really also see some tricky parts, right, Bob?
That's right. Yeah. That's where we get into, Tish talked earlier about fraudulent conveyance. And the spouse that's out of the trust is going to try to go about establishing that this was a fraudulent conveyance. It was set up to beat the marital estate out of property. And then it's left to a judge to decide whether or not that's true. And that's where the judge goes into the badges of fraud that Tish talked about. But, you know, it's a serious piece of litigation when you have to get into all that.
Well, and what about, you know, we've seen some cases recently, and I think you'll see this in, again, wealthy families that have been dealing with generational wealth, where they will have trusts that are set in place to have certain metrics. So either a metric of where it's going to be paid out after a certain age. Maybe they have to reach 35, 40, 45 years old. You know, it could be any age really. Or, you know, trusts that are set up with certain monies, and there would be a distribution for reasonable needs, right? You know, so those become a little bit more vague, if you will. Maybe not the first one. You know, the first one might say, well, you get distributions as needed per the discretion of the trustee, right? And neither of the parties are the trustee, and maybe only one of them's the beneficiary. But in those types of situations, I think it now you're continuing to add layers of complexity.